everyone, I'm Chloe Johnson and welcome to this Fresh Business Thinking webinar with Allard Bailey. Allard Bailey specialise in helping entrepreneurs, directors and investors to protect their professional interests from personal life events so they can achieve their lifetime ambitions and leave the legacy they intend. This is the final session in a three-part webinar series, and today we'll be discussing how your relationships can affect your business. I'd like to introduce you to our speakers today, Louise Allard, founding director of Allard Bailey Family Law. Louise has over 16 years experience of family law, including divorce, separation, adoption and surrogacy. Her clients come from all walks of life, including entrepreneurs, company directors, investors, shareholders and their spouses. Joining Louise for this webinar is Sabrina Bailey. Sabrina practiced family law at 2 legal 500 firms, as well as starting and selling a very successful non-legal business before co-founding Allard Bailey Family Law in 2016. She has a broad experience of all aspects of family law, including divorce and separation, involving business interests, international assets, and high net worth financial settlements. Louise and Sabrina will be talking for around 30 minutes and then we'll have some time for a Q&A. If you do have any questions you'd like to ask, you can leave them in the Q&A function at the bottom of your screen and we'll do our best to answer these later on in the session. That's all from me and I'll pass over to you, Louise and Sabrina.
Thank you for the introduction, Chloe. So hello everybody and welcome to today's webinar. As Chloe said, I'm Sabrina Bailey and I am a co-founder of Allard Bailey Family Law. We're a specialist family and private client firm, and joining me today is my colleague Louise, and we founded the firm together back in 2016. So as a firm, we recently sponsored the GBEA Awards, and it really was an absolute privilege to connect with so many entrepreneurs who are just starting out on their business journeys. And I think what really struck us was meeting so many innovative people with so many fresh ideas and plans who were actually putting these into practice. So the purpose of these webinars is to help you think about your long-term goals, and that's both personal and business, and to see if there's anything that you could be doing now to help you reach those goals. We're also going to look at whether there's anything you can do to protect yourself now and protect your business from things which may hinder you in the future.
Thank you, Sabrina. So in our first seminar, which I hosted with our colleague Sangeeta, we talked about the importance of your business structure and the difference it can make to have the right structure and agreements in place. We also spoke about tax planning to enable your business to grow efficiently so that you can maximize your impact as well as your personal return. In our second seminar, we went on to talk about how your personal life can impact your business, even perhaps hinder your business goals. And we talked about some cost-effective legal steps you can take to protect yourself and your business from situations such as your business partner's unexpected absence or your own personal debt. We also touched briefly on your personal relationships. Both of those webinars are available to watch on freshbusinessthinking.com. So in our third seminar today, hot on the heels of Valentine's Day, we're going to look at how the breakdown of a relationship could affect your business.
Thanks, Louise. So obviously nobody enters into a marriage considering divorce. And if you're in a happy relationship, then it doesn't feel like a natural thing to be considering. However, when you have a business, you have to have contingencies in place for all kinds of situations, and that does include divorce and separation. So today we will talk about the steps you can take and the issues you need to be aware of to protect yourself in the event of a relationship breakdown. And that goes both for whether you're married or whether you're cohabiting or simply in a relationship. We're also going to consider the different levels of involvement that your spouse might have in a business, and that could be from none at all to being an active member of the team, or perhaps even being your business partner.
And remember, it's not just your relationship that can affect your business. If you have business partners, you might want to discuss some of the protections we're going to talk about with them and possibly make them a condition of doing business with each other. And that's not to say that you don't have confidence in each other's relationships, just that you're realistic about the impact a relationship breakdown can have on the business you're working really hard to grow. And we're not talking about the toll it can take on an individual diverting their focus, but we're talking about the scenario in which your ex-spouse could potentially be given a share of the business, or your partner's ex-spouse could be given a share of the business that you are working in. So how do you protect against that? Well, the best way to protect yourself is to take out insurance. Take out that insurance before the event. And with that in mind, the obvious place to start is a prenuptial agreement or a prenup. So what is a prenup, and is it even relevant to me? You know, you might be thinking, I don't have much. I don't really have anything at all yet to protect. And when we first started practicing law 20 years ago, it's fair to say that prenups were not that common, and we tended to think about a prenup as something that would be asked for by wealthier clients. Often prenups had an international element because the sorts of clients we were assisting with prenups were trying to make sure that different legal approaches from different countries weren't going to conflict and cause a problem. But I would say that's really changed, wouldn't you, Sabrina?
Yes, it has. So the type of clients we tend to have making inquiries now are actually from all walks of life. And in fact, our biggest growth area is amongst young people who are just at the beginning of growing their assets, rather than wealthier older people that we were seeing previously. So, for example, we're working with a couple who are entering into a civil partnership. One is a business owner, the other is employed, so they do both have their own separate incomes. But they've actually decided to get a prenup because our client, who's the business owner, can make sure that both he, his business, and also his business partner are protected. Now, why would he want to do this? And the simple fact is that upon separation, business and his business would be seen as a marital asset that's actually capable of being shared. And that's even though the business was actually established before he was in that relationship.
Yeah. And so what is a prenup? Well, it's a contract. We are all in business, or at least attending a Fresh Business Thinking webinar, so we know what a contract is. And a prenup is a marriage contract, if you like, that sets out what you think should happen to your assets if you divorce. Because without that personalised marriage contract, you're agreeing to the standard marriage contract. And that contract is that you will share everything with the person you marry equally. And a business is an asset you can share. So, is a prenup enforceable? I raise that because that is a question that I'm asked a lot, because there is a lot of misinformation in the media. A prenup is not 100% legally binding in the strict sense of the law in this country, but courts in England will generally give a prenup significant weight, and they're often followed as long as there are no issues with it and it was drawn up properly and it's fair. And remember that word, because we're going to talk about that quite a lot later. If you don't think, therefore, it would be fair to give away a share of your business at a later date and you're getting married, then that's a conversation that you need to have now. If your business partner doesn't want to end up in business with your spouse, and if you don't want to end up in business with your business partner's spouse, then perhaps that's a wider chat that you should be having, not just with your potential spouse, but the rest of your business partners. So if a prenup's a contract, and you drop contracts at work, can you just download a contract from the internet, a standard prenup, to say we won't share anything if we separate, sign it, witness it, job done?
Well, I certainly wouldn't advise anybody to do that. So let's look back at the word you just mentioned, and that's fair. So a prenuptial agreement could actually be found to be invalid and set aside as if it didn't exist in the first place if it doesn't pass the test for fairness. So how do we work out whether a contract is fair? Well, firstly, the agreement should be reached and signed well before the wedding. So we would be looking at a minimum of 28 days. And it's, of course, common sense that if you're sat in the car on the way to the church and only just signing it at that stage, then there's obviously a real risk that that would be invalid. So both of you should also have the benefit of independent legal advice, just to make sure that you do understand what you are signing. So to successfully protect your business, please do seek independent advice. There also needs to be full financial disclosure of your financial position to your partner and vice versa. Something else to consider is that a change in circumstances in the future could affect your agreement. So you should get advice about that now, so you can include a clause in the agreement about what would happen if your circumstances change. And looking at review clauses as well for prenuptial agreements is really important. For example, your life could look really different in 5 years' time, 10 years' time, especially if you go on to have children with your spouse. So what might be a fair agreement today may not be fair in the future.
So let's go back to the client that you mentioned before who wants to protect his business. If the prenup is fair, then one of the things that we will have to demonstrate is that both parties have to be provided for if they do divorce. So it might be okay to ring fence our client's business, but we have to consider what that means for his partner. Should he be compensated in some way? Or, for example, does he have assets of his own that he can keep? And therefore, that would be fair. If the prenup, for example, meant our client was okay, but his ex was in financial hardship, then that could be problematic for the court, and it could be disregarded and completely set aside. So when I'm sitting down with a client and looking at their assets in this scenario, I'm also looking at how their partner would be provided for upon divorce, but in a way perhaps that wouldn't touch the business interest if that's what they want to preserve. And if there aren't sufficient assets to go around without including the business, my client needs to know that right now from the outset before getting married, so there's no nasty surprises.
Yes, and I think one of the most obvious things you may want your prenup to do is to say that your business is completely separate property and it can't be shared at a later date. But that's not actually your only option, and there are lots of other things you could consider. So, for example, your prenup could say that any value that's added to the business following the marriage is the only part of the business that can be shared, or you may wish to limit your partner's share to a particular percentage. And that might actually be a really fair thing to do. So, for example, if they're going to be supporting you in the business, or perhaps even working in the business, then it is fair that they are compensated for at a later date should you separate.
Yes, I mean, for example, sorry,
no, I was going to say we'll talk about partners working together in a business shortly.
Thanks. I was just going to say that I had one client, for example, who was a business owner, and when he married, he decided to give his wife shares in the business. So it was very much accepted that from then on it was a shared asset. But what the prenup did was to specify what would happen to the shares if they separated. And the prenup said that the husband would be entitled to buy back the wife's shares if they divorced, so he could keep control of his business. In this scenario, the wife would still be compensated for her shares, but he kept his business. Now, in this case, they did separate, and at that point, the wife didn't agree she should be held to the prenup because there were dividends at that stage that she wanted to remain entitled to. But a judge decided the husband had only transferred the shares due to her agreement that she would transfer them back, and he was entitled to buy back the shares. If they hadn't had the prenup, then it could have had a very different ending.
Yes, so prenups are a really good option for anybody who is thinking about marriage. But what if you're already married, or you're going into business with somebody that is married themselves? Well, it's still not too late to protect your business. We also see an increasing amount of people making inquiries about postnups. Now, a postnup is effectively the same as a prenup, but it can actually be put into place following your marriage. So very similar rules apply to postnups as prenups. So obviously they must be fair. You should have some independent legal advice about what you're agreeing to. And really importantly, it's vital that nobody feels uncomfortable or pressured into signing any agreements. So as a firm, we have really close links with a commercial law firm, and we often work with them to give advice to founders of startups where a postnup might be one of the conditions of the business. And that way founders can really be sure that as far as possible, their joint enterprise is protected in the future.
Of course, prenups and postnups are only really relevant to you if you're getting married or if you're already married. But we also advise lots of couples who are not married, and there has been, for example, a mingling of private money and business money, or where the lines between romantic partner and working partner have become blurred. For example, where loans have been made by partners with no accompanying documentation, no evidence to show whether money has in fact been given as a loan or a gift, or in exchange for a share of the business. So having the correct documentation in place is really important, whether you're married or not. And we've dealt with countless cases where a lack of evidence and documentation has been a real problem.
That's right. And for example, I recently helped a client. She was a business owner. Her mother had loaned a really large sum of money into the business. At the time, they had spoken about drawing up a deed of trust, but it was something they just didn't get round to doing. So there was nothing in writing to document that actually that loan into the business had to be repaid to the mother. So unfortunately, my client separated from her husband, and he was then adamant the money was a gift rather than a loan for the benefit of both of them into the business, making it a business asset. So he then wants to be compensated for this amount. And my client was arguing, well, actually, it's a debt, so that makes the business grossly overvalued if you're not taking the debt into account. And unfortunately, as an agreement couldn't be reached, my client had no choice but to enter into court proceedings, which, as you can imagine, was extremely stressful and lengthy and expensive. And really, all of this could have been avoided if it had been documented correctly in the first place.
Absolutely. I mean, documentation is so important. It actually brings to mind another case where my client had borrowed money from his parents to purchase shares. Now, when he and his wife separated, the shares weren't worth anything, so that wasn't the issue, that wasn't an asset. But the problem was this debt still existed. My client said it was a joint debt. The shares were to benefit both of them, and his parents should be repaid from the sale of the family home because his wife knew about the debt. She had agreed to take the loan from his parents. But in this case, the wife said, no, that was not correct. She said it was what we would refer to as a soft loan, and the husband didn't have to pay it back, and she didn't really know about it in the first place. Now, unfortunately, my client didn't have the funds to take this one to court. He had a lot of circumstantial evidence and emails, but nothing concrete. So he had to walk away from the situation, and the loan from his parents stayed with him. And it's another case where proper documentation would have massively assisted. So, you know, the evidence of a loan is essential, but there are some very easy steps that you can take to make sure that your business life is kept separate from your personal life and the correct documentation is in place. And these are steps you can really take from the outset, especially at the beginning of a new business venture. Although it can be tempting at first to make payments for business expenses out of personal accounts, we would advise you not to do that, to set up separate business accounts from the outset and record. So that's an easy step you can take. But another issue that we often have to deal with is when you're employing your partner in your business. And there are two different scenarios that we want to talk about. Sometimes we find business owners employing their spouses or partners, but their spouse is in reality doing very little work for the business. Not only that could that potentially be fraudulent from a tax perspective, it also can be very difficult to say at a later stage that your partner is not really employed by the business and they're not really involved in the business. So just be really, really careful about that.
Yes, and a second and more common scenario that we see is actually when someone is genuinely employing their spouse. And of course, it's not uncommon to want to work together, but I think it can be really difficult to miss the step of defining the parameters of that employment. So in a usual situation, we would of course have employment contracts for our employees. And it really is important that if your spouse is working for you, they also have an employment contract. So equally, if your spouse is being paid, then you should be paying them the market rates for their job role. So if there's ever a disagreement at a later stage, at least it's really clear what your partner's employment status has been. And also remember, whilst I'm not an employment lawyer, so I'm not going to give employment law advice, but it is common sense that just because you separate from somebody, that does not make it a good reason for you to sack them, no matter how tempting that might be.
Yeah, and I can imagine it is from time to time. But separation, seriously, is hard enough. And if you've been living and working together, it can be even harder. We still get a lot of people coming to us to say that they've been living and working together, they're separating and they want to separate their assets, they're not married, and they don't have any documentation about their school, their home and their business, but that's okay because they are common law husband and wife. So I can't say this enough, there is no such thing as common law husband and wife. It is a myth. It doesn't matter how long you've lived with somebody, the law treats couples very differently, whether they're married or not. And I hope we've already impressed on you the importance of having the right documentation in place if you're married or not. But think about how you're going to hold assets from the outset well in advance of any possible separation. If you're getting married, we've already discussed taking out early insurance by way of a prenup. But if you're not married and you're not planning to get married, but you are living together and perhaps working together, there is another step you can take. And really, because unmarried people potentially have a very complicated way through the courts to separate assets if they disagree, one thing I always recommend to people moving in together, but particularly if you're living and working together, is a cohabitation agreement. Now, what is a cohabitation agreement? Well, we're back to contracts. A cohabitation agreement is a contract, and if properly executed, so signed in the right way, it will almost always be upheld by the court. And it's not enough to say, I'm protected because everything is in my name. I don't need anything like a cohabitation agreement because I'm not married. It's true that if you're not married, you don't have the same automatic rights to share someone else's property, but you can acquire rights in someone else's property and they can acquire rights in your property. So it's generally a lot more expensive to sort out legally if you're not married and you disagree. So why take that risk when you can enter into a really straightforward agreement that sets out your intentions as to who will own what will happen to assets if your relationship breaks down.
Thanks, Louise. Yes, and just to give you an example, we had a client recently who had been living with her partner. It was a jointly owned property, in fact, and there were actually business loans secured on the property. Now, because it was her partner's business, she didn't benefit from these loans at all. And the original intention was that the loans would be secured on his share of the property only. Again, unfortunately, they didn't actually take any steps to document this. So there was no evidence of any agreement reached. And therefore, for our clients, when the parties did separate, it was extremely stressful for her. And it took a really long time to negotiate a fair settlement for her.
I mean, yes, these are really some of the most stressful cases we have to deal with. One of my clients spent 40 years building his business, and when he separated from his partner, she alleged that he had always told her it was their business, and she made a case for the property he owned and the business in reality being shared. And although legally these assets were not in joint names, it was a hugely stressful journey for my client and actually quite costly. because in the end, although he kept his business, he gave away part of his share of other property to settle the matter. And this, one of the worst parts for him was it was just a lot of added stress at what was already a difficult time. And we could have saved him a lot of that stress with early intervention.
That's right. And today we've talked a lot about the kind of things you can do to protect yourself before anything happens. And I think as lawyers, we would both agree that those are the kinds of situations that we really like helping with. So that's before there's any breakdown of a relationship, where people are working together towards a common goal. And it also means we can work collaboratively with the other solicitor too. And despite what you think, most lawyers don't actually like confrontation. We just want to help sort things out.
Most definitely. But the truth is, the majority of people that we help that are separating don't have protections in place. And there is definitely no criticism here. Solicitors are actually sometimes the worst for finding themselves in this position, a bit like the plumber who never fixes his own leaky pipe. So what can you do if you're separating and you're worried about your business or your assets and you don't have prenups and cohab agreements? Well, the first thing I would advise you to do is take stock and speak to someone who can give you some proper advice. Speak to a solicitor, but someone that's going to give you balanced advice, not someone looking to have a fight with your money. And finding that person can be pretty daunting.
Yes, it can. And I think if you're looking for a family lawyer, the first port of call really should be the Resolution website. Now, Resolution is an organisation of family lawyers who are committed to working with families and individuals to resolve issues in a constructive way. So if you go on the Resolution website, you'll see that they have a list of family lawyers who are all signed up to their charter, and you can actually search for a lawyer by area. Although obviously in these COVID lockdown times, location really isn't as important as it once was when choosing a lawyer.
No, I mean, absolutely, that's very true. We have clients in Wales and all over England. And one thing about virtual working is you, the consumer, actually has a far greater choice now. So by visiting the website, you will be bound to find somebody who can help you. There will be a lot to choose from.
Absolutely. And it really is important that you feel comfortable with your lawyer. And lots of lawyers will be happy to have a short telephone call with you, 10 to 15 minutes, so that you can really get a feel for how they work and whether you would work well together.
Absolutely. And I would really say take time to do that, because when you start working with someone, be realistic, it's likely to be a bit of a journey, particularly if you're separating and you've got to untangle lots of business interests. There is potentially a lot to sort out. If you're at the beginning of the process, one of the first things that you will need to do is go through what we call disclosure. That is essentially telling each other all the details of all your assets and your business assets too. You may very well need to have your business assets valued. So it's really important to speak to someone who can guide you as to how to do that. And this stage can be a bit of a shock for everyone. We've had clients who've been enjoying a lavish lifestyle, believing their spouse's business is booming, only to find they're in huge debt, as well as clients who are doing much better than their spouse was aware. But whatever your situation, we would advise you just to be open with your spouse, find the right person to talk to, and you'll find a practical solution. Because there will be an answer as to how to move forward and move on, because there always is. And there's lots of options to resolve things, not just solicitors, not just court. In fact, thinking strategically, in most cases, you'll want to avoid court if at all possible. But mediation, arbitration, good old-fashioned negotiation are just some of the available options that can help you resolve the knotty issues that you might face on separation.
Thanks, Louise. Yeah, and I really hope today has been helpful for you all and has given you a bit of an insight into the kinds of areas that we're able to help clients with, particularly clients like yourselves who have businesses.
Okay, so we've got some time for some questions here. and I am hoping that I can work the Q&A chat, that my technical skills will hold up. So we've got some questions here. Can you see them as well, Sabrina?
I can, yes.
Okay.
So the first one is it too late to send a prenup to my wife after a year of marriage?
I would say no. I'm not sure I would just send it to her. I would maybe have a discussion with her. We did touch on it briefly. We were talking about postnups in our seminar. So a prenup, that would be a document you sign before you married, but a postnup does the same thing really, and it's a document that you would sign after you're married. So absolutely, that's still a discussion that you can have. But it should be a discussion and terms you agree together, rather than I wouldn't just send it. But
yeah, I think it is certainly something that shouldn't be imposed on the other person. And again, if somebody is signing a postnup under duress, then again that probably wouldn't be found to be valid. So it's something that really needs to be discussed, and you would both need to have independent legal advice.
Yeah. Okay, so there is another question there. So what sort of information goes into a cohabitation agreement? So really, it can cover all sorts of things. I mean, actually, you have a lot more flexibility with a cohabitation agreement than you do with the prenuptial agreement. There is not the same emphasis in a cohabitation agreement, to be fair. So, for example, if you own your own property and you own your own business, but you decide that your partner is going to move in with you and you want to make really sure that that is protected, you can have a cohabitation agreement that's drafted to say that on separation, you will just retain all of your assets. The business will stay with you, the property will stay with you, that just by living together and even working together, you're not acquiring an interest in that business and that property. And it might be difficult in a prenup to completely exclude somebody from obtaining any rights over your property. That's not the case in a cohabitation agreement. If both of you, if you're living together, agree on what should happen to assets if you separate, and you record those in a proper agreement, then there's no reason really why that shouldn't be upheld. So, but there can be information about what happens to your property, or a car that you jointly own, or that one of you owns and is using, or what happens to the things in your house or parts of your business. It can cover really anything at all. Okay. Right.
So,
the next question that we've been asked is, if my partner and I both have our own businesses, do we need a prenup, or should we just keep our own businesses if we separated? So the answer to that question is, it depends. That's the answer to lots of family law questions. It really just depends. It depends on the individual circumstances of your case, but particularly if you're married, you should, if that's what you want to do, keep your own businesses. It's probably a good idea to get some advice at this stage as to whether or not in your particular case you would be able to retain your own business.
Yes, I think it could also, obviously, it could depend on the values of the businesses, and you also need to look at whether there are any other assets. So if you had a business valued at 5 million and you wanted to keep that, perhaps if the family home was valued at something similar, then there's always ways around it to structure any kind of prenup.
So the next question, which actually Sabrina sort of touched on an answer to, what happens if my partner who works with me won't sign an agreement? Well, any kind of agreement has to be entered into freely, with both sides having complete understanding of what that agreement is, and both agreeing to it without any duress. So if your partner or your business partner won't sign an agreement, there's nothing you can do to make them sign that agreement. But what you might want to do is take some advice as to what could happen in certain scenarios. Would your business be impacted, or actually are you protected in other ways? Is there very little risk to your business anyway? So it might be something that you want to that you want to take some advice about? Okay, so this is a good question. Won't a prenup kill our romance and mean we don't trust each other? Actually, no. And what is so interesting is we are seeing lots more younger people coming to us for advice about this, because both parties just take a really pragmatic approach. You know, perhaps they've had parents who divorced and it was very messy and there was a lot of hurt and upset, and they just want to take any sting out of any separation. It's not saying that you're going to separate, and prenup doesn't mean that you will separate. It just gives you the opportunity to sit down and think about what you would want to happen when you are not in a place of hurt and upset, and you can do it calmly. And hopefully you just put it in a drawer, shut that drawer and forget about it, and you never need to use it again. But it's a bit like, you know, it's like having an umbrella for a rainy day. If you do need it, then it's there.
Yeah, so it's just that insurance, isn't it?
Absolutely.
We take out insurance in other areas of our lives. So
absolutely. So we've got a question here from Martin, a financial advisor. Is there anything I should be asking couples to do with their finances? Well, that's a question we should be asking you, Martin, about what you should do with their finances. I suppose that is really, in some ways, I'm going to back that question back to the financial advisors, because what we will advise clients about, our area of expertise is we can tell them what we think will happen in different scenarios to perhaps their assets, and how we can help them protect. I suppose in terms of what a financial advisor should be telling their clients in order to protect them, speak to a family law solicitor is what you should be telling your clients, and then hopefully you can give your clients lots and lots of advice about how to grow their money and how to protect their money in different ways.
That's right. I mean, from a financial advisor's point of view, I guess it just might be an issue of how to structure any assets.
Yeah. So we've got one last question, which I'm thinking of moving in with my partner and talking about how things will work. Is a cohabitation agreement only if we separate? Actually, that's a really good point. Absolutely not. You could set out rules for the relationship in that cohabitation agreement. So if you want to record who will pay for what, who will do what, then absolutely that's something that can be in your cohabitation agreement, and you can specify that from the start. And a cohabitation agreement, like a prenuptial agreement, it can evolve over time. It changes. It's not necessarily, you know, a static document that you adhere to religiously. The hope is that it gives you a structure and a framework, but as you change and as your life change, it's likely to evolve over time.
Yes, and I think that's why it's a good idea to have review clauses in any kind of agreement. You know, you could review it once a year, once every 2 years, just so that if any circumstances have changed, you can amend it accordingly.
Okay, so I think that's all from the questions, but if anybody does have any questions arising out of what we've spoken about today, then our contact details are on the side, and you can feel free to drop us a personal email and we'd be happy to answer any questions that you have.
Thank you, everybody.
Louise and Sabrina, thank you so much for taking the time to join us on this webinar. I'm sure our audience will agree that was an incredibly informative session. And just to echo what Louise has said, their email addresses are in the chat section if you would like to ask any further questions. Louise and Sabrina, do you have any final words before we sign off?
I think just my final words are just enjoy the sunshine, which I've had to keep adjusting my head because it's blaring through the window here. And yeah, thank you all very much for tuning in, and it's been a real pleasure to be able to speak to you all, and hope to connect with some of you in the future.
Fantastic. If there is anything you'd like to catch up on from today's session, we'll be sending out a replay of the webinar coming at 5 p.m. today. You can find the replay and part 1 and 2 of the Allard Bailey webinar series at www.freshbusinessthinking.haysummit.com or by clicking on the link in the comment section. Thank you very much for joining us today, and thank you again, Louise and Sabrina. Goodbye, everybody.